Hello, my name is Eric Willison, and I am an attorney in the Central Ohio area. I've been certified to practice in Ohio and only Ohio since 1996. I broke out the calculator last night and did some calculations. I found out that was 117,000 years ago. So I've got a little bit of experience. This is going to be a series of videos on representing yourself. And there's going to be some pitfalls to representing yourself, and I want to make sure that you know all about them. First thing to know is that you can always represent yourself in court, but you can't represent somebody else, and you can't represent a legal entity, even a legal entity that you own, lock, stock, and barrel, like your own company. You can't represent that unless you're an attorney certified to practice in Ohio. Now, some people will say, oh, don't worry about that. I went and got a power of attorney, so now I can represent this company, or I can represent somebody else for whom I have the power of attorney. Not true. What happens with the power of attorney is that you get to step inside the legal shoes of that person, but you don't get to stand up on your hind legs and represent them in court as if you were an attorney. Okay? So if it comes to needing to move money from one bank account to another, if you have a power of attorney, you can do that. If it comes to signing a lease for a landlord who might be out of town and you're going to be watching over his affairs and you've got power of attorney, then you can do that. But it does not allow you to come into court and say, I'm an attorney now for the purposes of this guy because I've got power of attorney. It's two totally separate things. A power of attorney does not let you represent somebody else. You can always represent yourself in court, but should you? There's problems here. If you don't have a law degree and you've not practiced before, you're going to be at an immense procedural disadvantage. That means no matter how smart you are and how dumb the certified to practice attorney is who might be going against you, he or she is going to have an advantage because he or she knows how the game is played. Let's make a football analogy. You could be the greatest linebacker to ever play NFL football. Absolutely. Whether that be Ray Lewis for the Baltimore Ravens or whoever it was, you could be the greatest ever at the position, the greatest athlete, the fastest, the highest jumping, the strongest, the best tackling, the smartest, everything. But you take that person off the football field and you put him on a rugby pitch where he doesn't know the rules. A non-professional amateur club rugby team is going to beat the tar out of a bunch of guys like that because they don't know which way is up. They don't know how to score. They don't know how to throw the ball in from the sidelines. They don't know anything about the rules of rugby. So it doesn't matter how smart you are. It doesn't matter how cool you are under pressure and how great you are at coming up with witty repartee. It doesn't matter. If you don't know the rules, you're going to get killed. Another advantage that you're going to be at is that you're going to be at a subject matter disadvantage. Attorneys will tend, I don't want to say to specialize, but they will tend to concentrate their practice in certain areas that they've become comfortable in. Maybe somebody just does evictions, or maybe somebody just does criminal law or medical malpractice or tax law or whatever. They're going to tend to concentrate their practice in one, maybe two or three areas, but that's about it, okay? And if you go up against one of those people, they're going to have 10, 15, 20 years of experience within that subject matter area. They're going to know all the ins and outs, the exceptions to the rules, everything. You're going to be at a really bad disadvantage there. Further, there's an exception here to that rule, by the way, for a small claims court. When you go into small claims court, the magistrate will typically tend to protect a pro se plaintiff from one who's represented from being sort of torn apart by somebody who really knows the law as far as being an attorney goes. Because small claims court is made for pro se disputes. Small disputes, usually $6,000 and less. So there will be a little bit of an exception there. A magistrate will sort of say, well, we're going to make an exception here, and we're going to make sure that this guy's evidence comes in, even though he doesn't know how to get evidence in. So the other disadvantages you're going to be at is this, what I call the subjective and objective disadvantages. If you're a party to the case, and you have to be representing yourself, then you're a subjective person. Whatever happened in the case that was bad, it happened to you. You felt the sting of it. Subjectively, you felt the sting of it, okay? You didn't get the chance, for whatever reason, to go to an attorney who did not feel the sting of it. He just sort of hears it from you and maybe shake his or her head or say, well, that was terrible, or so on and so forth. But that attorney will have an advantage because that attorney will take an objective view of things, an unemotional view of things, a detached sort of 30,000-foot view of things, whereas you were right there in the fight, if you will, that caused this whole issue. You're going to have some raw nerves, you're going to have some sensitivity about this or that from the other side. The attorney's not going to have that. The attorney does this all the time. This is just another case to him. And that cool-headedness, that objectivity, that being a little bit removed from the situation is a big, big advantage in court. So you're not going to have that because you're a subjective party. The attorney for the other side will have that because he or she is objective and a little bit pulled back. Now, that said, there may be some reason why you have to represent yourself. I would say it's, if you're going to represent yourself and use what I'm going to teach you here about all this, you're going to want to do this on an emergency basis, just sort of to buy enough time to get yourself an attorney. So picture what you're going to learn in these videos as how to pilot the lifeboat, but this is not how to pilot the ocean liner, okay? For that, you're going to need an attorney. So that's one way of looking at it. Another way might be, I can pay all these bills and get back to square one, but I can't do it right now. I can't do it this month, but I've got 2 or 3 big checks coming in about a month or so. If I just know enough how to delay this lawsuit for 3 or 4 weeks and avoid a default judgment, then I'll have enough money to hire an attorney to take over, or I'll have enough money to go to the other side and say, look, I know I owe you $12,000. I've got the money, here it is. Will you settle the lawsuit? Then that would be a good reason maybe to represent yourself for a while. Sometimes it might be a good idea to represent yourself and to use the information here, even though you can't afford an attorney and you're not going to be able to afford an attorney. But the idea here is that if you can show that you're capable of producing good solid pleadings and motions and all that sort of thing, as far as the format goes, another attorney might look at you and say, this guy's maybe just got enough knowledge here to be dangerous. Maybe we could maybe we'll, out of all the 100 other cases we've got that's just like this one, let's just settle with him or her, and we're going to go after all the other easy marks later. It's sort of like the bully in the schoolyard. Even though he's picking on somebody who's 5'2", 5'3", if that kid jumps up and punches him in the nose, that 5'2" or 5'3" kid is probably going to get beat up in the end. But next time they come together, that was the guy that beat me, that hit me in the nose. Easier picking somewhere else. So there's that. And then lastly, there may just be absolutely no other choice. It's something you have to do. It's something you have to represent yourself. And you might make a mess of it, but it's better than just ignoring it and getting a judgment against you. Who knows? I can see how that would happen. So again, I'm going to try to provide you with the information that you'll need to represent yourself in this series. Lastly, however, I'm going to give you this is maybe not really legal advice, but it's more practical advice about whether you want to get into a lawsuit or not. Let me give you an analogy here. Great lawyers are a lot like great fighter pilots from World War II or the Korean War, or really even today probably. And what the really, really great fighter pilots were good at was making the go, no-go decision. So they're flying at 10,000 feet, 15,000 feet above the fray. They look down, they see a bunch of people, down around 5,000 feet, and they're all locked in combat, zipping back and forth, and so on and so forth. The great ones look down there and they start counting, and they say, okay, I see 12 US planes and I see 4 German planes. That's a go decision. We're going to come in from 15,000 feet. We're going to be coming in at 400 or 500 miles an hour. We're going to make a few passes. We're going to put lead on the targets of the guys that are right behind some of our guys. We're going to totally wipe the last of them out. We're going to pull up, go back up altitude, come back down again. We're going to keep doing that until those guys are gone. That's a good go decision, okay? But if they are going along and they look down and they see, okay, there's 30 German planes down there and there's 7 US planes, and we only have 5 planes up here, that's a no-go decision. Those guys got into their problem for whatever reason. I don't know why, but if we go down there, we're just going to add to the losses. So that's a no-go decision. Now you're probably thinking to yourself, but hey, if I get sued, there is no no-go decision. It's I'm either in court or I'm not. But maybe let's think about this. Let's say you're a landlord and you've got a problem tenant, and he wants out of the lease, and you kind of want him out of the lease too, but he's not going, but he's sort of making a lot of noise and disturbing the other tenants around. They're complaining. It's just going to be a bad scene. So now you can go and hire an attorney, and that attorney's going to charge you, at say the year 2020 prices, probably $300 to do the eviction and attorney's fees. You're going to be looking at maybe $150 for the filing fees for the court, maybe another $50 in post decision fees to do a writ of restitution and a press fee for set out to actually get him out of the premises, and then also you might have to hire a work crew to get all of his stuff out. You have to do that anyway. But what if this what if this landlord decides in this true no-go fashion, what if he decides, instead of just going and hiring that lawyer, which is probably going to cost him just north of $500, what if he goes to the tenant and says, hey tenant, I will give you $200 in cash if you'll sign this agreed entry here, agreeing to be out. Well, let's see, it's the 15th of January today. Let's say you're out by the 30th of January. I'll pay you $200 to sign this agreement that you'll be out by the 30th of January. And in the agreement, it will say that in addition to that, if you actually hand me the keys and sign off on it, I will give you another $200 in cash. That's $400, 200 down, 200 later if you do what you say you're going to do. Now the tenant might be like, yeah, this is perfect. I can get out of here. I've got just enough to get another deposit somewhere, maybe first month's rent with the other stuff I've got saved. I get out of this lease with this landlord I don't like. Let's get out. Let's do it. Okay. Now some landlords are thinking, why should I give this guy money? He owes me. But here's the thing: you are going to pay the attorney $500. Here you pay the tenant $400. Plus now you're going to get him out in 2 weeks, whereas with the attorney, the earliest you're going to get him out, at least in an Ohio eviction, usually going to be about 4 weeks. So that's a no-go decision. You could maybe get what you want by bargaining with this person and structuring it so that you can be successful. The same thing maybe if you're the tenant and the landlord puts a 3-day notice to vacate up on the door. It says 3 days to vacate. Well, get your stuff and get out. Or go to him and say, look, don't file the eviction. I'll be out by the 15th, or I'll be out by the 30th, and we'll do that. And I'll give you money now, and I'll give you money then. Or you can keep my deposit or whatever. We'll sign an agreement. We'll sign a surrender of the lease. That's going to be cheaper for the landlord because he doesn't have to hire the attorney. He may just say, you know what, I didn't get everything I wanted, but I got the guy out. That's the no-go decision. As an attorney, when I first started out, I used to represent a lot of tenants. And I would meet 10 groups of tenants who were being evicted, and I would usually, to represent them, I would usually only pick 1, maybe 2 out of the 10. And it wasn't because I just liked the way they looked. It was because those two groups of tenants, or maybe even just a one, or maybe none, those groups had a real defense that I could actually win on. I mean, there's a lot of attorneys down there. Oh, being evicted. Well, why is that? I didn't pay the rent. Oh, well, give me $300 and I'll go down and fight for you. There's nothing they can do for you other than just give you the $300. And when those people came into me, I said, look, keep the $300. Go back to your landlord. Offer him the $300. See if you can get out or whatever. But you're not going to be able to defeat this eviction. It's just not going to happen. And I'm not going to take your money and just be more of a problem for you. Okay? Now, you can call it selflessness, but it really wasn't selfless. Because what happened was, whenever I came in to the courtroom, and if I'm only representing people that I think I can win on, that I'm really sure that I can win on, then I started to get this reputation as the attorney who would walk in, and if you saw him, oh man, what did I do wrong? How did my landlord mess this up? How did I mess it up? What happened here? And that literally started to happen. There was only about 5 or 6 attorneys in town that were really doing a lot of evictions. They all knew me. I would walk in, they would see me and they would laugh and they'd say, "Are you here for me?" And I said, No, I'm here for you. And then the one guy go, "Oh, what did I do wrong?" And then you show me, "Okay, let's do an agreed entry, let's work it out." All right. And so I got that reputation, and I started to get that reputation too in front of the judges. So when they saw me coming, they always knew I had something. So again, that's the go, no-go decision for attorneys, okay? So you only fight where you have an advantage. And if you're going to use what I'm going to teach you here about the way the system works and all that sort of thing, then what I want you to do is think of this as the lifeboat. This is how to run the lifeboat. It's not how to run the ocean liner.